Welcome to Mixed Magic Theater's We, They, and the People series. We, They, and the People is a Mixed Magic Theater civic engagement series that explores and dramatizes Supreme Court cases that have had a significant impact on the lives of all Americans, but especially its Black citizens. This project is supported by the XIX Shall Not Be Denied Why It Matters initiative of the Rhode Island Council for the Humanities, part of the nationwide Why It Matters Civic and Electoral Participation initiative, administered by the Federation of State Humanities Councils and funded by the Andrew W. Mellon Foundation. This Theater at a Distance project is a donation-based streaming experience. All events are streamed on Mixed Magic Theater's YouTube channel. To subscribe to our YouTube channel and to support Mixed Magic Theater, please visit mmtri.org to make a donation. Thank you for your support, and as always, thank you for believing in magic.
It is difficult to write an overview or history of police shootings of unarmed Black people in America. How or where does one begin to explain the record of largely disregarded violence at the hands of the state? Perhaps it is best to start with the hundreds of years of enslavement of Africans in America, where unchecked brutality by sanctioned overseers or plantation owners was used as a means to subjugate or control Black men and women. Slave patrols, an early form of American policing, authored by Chelsea Hansen in 2019, wrote the following.
I, patroller's name, do swear that I will, as searcher for guns, swords, and other weapons among the slaves in my district, faithfully and as privately as I can, discharge the trust reposed in me as the law directs to the best of my power. So help me God. Slave Patroller's Oath, North Carolina, 1828.
The American South relied almost exclusively on slave labor, and white Southerners lived in near constant fear of slave rebellions disrupting this economic status quo. As a result, these patrols were one of the earliest and most prolific forms of early policing in the South. The responsibility of patrols was straightforward: to control the movements and behaviors of enslaved populations. According to historian Gary Potter, slave patrols served three main functions. 1. To chase down, apprehend, and return to their owners runaway slaves. 2. To provide a form of organized terror to deter slave revolts. And 3. To maintain and form of discipline for slave workers who were subject to summary justice outside the law. Organized policing was one of the many types of social controls imposed on enslaved African Americans in the South. Physical and psychological violence took many forms, including an overseer's brutal whip, the intentional breakup of families, deprivation of food and other necessities, and the private employment of slave catchers to track down runaways. As historian Sally Haddon writes in her book, Slave Patrols, Law and Violence in Virginia and the Carolinas, the history of police work in the South grows out of this early fascination by white patrollers with what African American slaves were doing. Most law enforcement was, by definition, white patrolmen watching, catching, or beating Black slaves. First formed in 1704 in South Carolina, these patrols lasted over 150 years, only technically ending with the abolition of slavery during the Civil War. However, just because the patrols lost their lawful status did not mean that their influence died out in 1865. Haddon argues there are distinct parallels between the legal slave patrols before the war and extralegal terrorization tactics used by vigilante groups during Reconstruction, most notoriously the Ku Klux Klan. Though law enforcement looks very different today, the profession developed from practices implemented in the colonies. Where does one begin to tell the story? Should they begin during Reconstruction, when so-called officers of the law, often referred to by the pejorative patty rollers, for their abuses inflicted upon Irish immigrant, terrorized Black communities into the South, throughout the country? These peace officers, often former Confederate soldiers and active Klan members, were allowed to do what they pleased without fear of punishment. One can spend a lifetime chronicling the history of police and their interactions with the Black community from the founding of the United States until present. It is a history rife with tragic stories of brutality and disregard for the laws of the land. It is a history of state-sanctioned violence that was and continues to be excused at all levels of government as individuals and institutions turned a blind eye to the inhumanity and violence being heaped upon a people, mostly due to the color of their skin. In 2020, public intellectual Renee Ader published In Memoriam, I Can't Breathe. In it she wrote,
I am angry. I am anguished. I am heartbroken. I am hollowed out. I am sick and tired of police needlessly killing Black and brown people. Some police still see Black men as threats to brutalize, to contain, to remand. They have stereotyped our grandfathers, fathers, husbands, sons, and nephews as monsters subject to violence and death. They have killed our grandmothers, mothers, wives, daughters, and nieces. Every time I watch the video of George Floyd's death, my heart weeps. Who in their right mind kneels on another human's neck and ignores desperate pleas of, I can't breathe? Where's the humanity of these white police officers? Policing should not be predicated on brutal force and a complete disdain for Black life. White supremacy has no place in the criminal justice system, in government, in the White House, in the United States. Black lives matter every second, every minute, every hour, every day. In Memoriam, the universe shrank when you went away. Every time I thought your name, stars fell on me. Henry Dumas, poet, social activist, teacher.
Ader's article was followed by a listing of unarmed Black men and women shot by the police, beginning with Henry Dumas on May 23, 1968, in New York City, and ending with Patrick Lynn Warren Sr. in Killeen, Texas, on March 2, 2021. 1968 to 2021. Just a fraction of the statistic, and still over 29 pages long. This 29-page necrology serves as a sad reminder of a great many things, not the least of which being the conversation, a painful rite of passage for Black parents as they explain to their children the rules of engagement with police. To understand this tragic reality is not to simply acknowledge a history that has been. It is to grapple with the structures and systems that continue to be. In a sad chronicle that can be discussed myriad of ways, let us take a moment to explore and understand the case of Tennessee versus Garner. Facts of the case. On October 3, 1974, 2 police officers responded to a late-night call. A woman heard glass breaking in her neighbor's house and believed a prowler to be inside. One of the officers went around to the back of the house. Someone fled across the backyard, stopping by a 6-foot fence. In the darkness, the officer could see that it was a boy and reasonably believed the boy to be unarmed. The officer yelled, "Police, halt!" That boy jumped up and began to climb the 6-foot fence. Out of fear that he'd lose the arrest, the officer opened fire, striking the boy in the back of the head. The boy, Edward Garner, died at the hospital. Garner had stolen a purse and $10. Under Tennessee law, the officer's conduct was legal. The state's law reads, if after notice of the intention to arrest a defendant, he either flee, forcibly resist, the officer may use all the necessary means to effect the arrest. Garner's death sparked over a decade of court battles, resulting in a Supreme Court ruling in 1985. Constitutional issues. Can a police officer use deadly force against a fleeing, unarmed suspect? Does a statute that authorizes that use of deadly force on an unarmed suspect violate the Fourth Amendment of the U.S. Constitution? The arguments. Attorneys on behalf of the state and city argued that the Fourth Amendment oversees whether a person may be detained, but not how they may be apprehended. They argued that violence decreases when officers are able to do their jobs by any means necessary. The ability to resort to deadly force is a meaningful threat to deter violence and is in the interest of the city and state. Furthermore, the state's legal team argued that the use of deadly force against a fleeing suspect was reasonable. Common law revealed that, at the time of the Supreme Court's ruling, multiple states still permitted this type of force. The practice was even more common at the time of the passage of the Fourth Amendment, nearly 2 centuries before. The respondent, Garner's father, alleges that the officer had violated his son's Fourth Amendment rights, his right to due process, his Sixth Amendment right to trial by jury, and his Eighth Amendment protections against cruel and unusual punishment. The court only accepted the Fourth Amendment and due process claims.
This case requires us to determine the constitutionality of the use of deadly force to prevent the escape of an apparently unarmed suspected felon. We concluded that such force may not be used unless it is necessary to prevent the escape and the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. In using deadly force to prevent the escape, Hyman was acting under the authority of a Tennessee statute and pursuant to police department policy. The statute provides that if, after notice of the intention to arrest the defendant, he either flees or forcibly resists, the officer may use all the necessary means to effect the arrest. The department policy was slightly more restrictive than the statute, but still allowed the use of deadly force in cases of burglary. The incident was reviewed by the Memphis Police Firearms Review Board and presented to a grand jury. Neither took action.
Although the circumstances of this case are unquestionably tragic and unfortunate, our constitutional holdings must be sensitive both to the history of the Fourth Amendment and to the general implications of the court's reasoning. By disregarding the serious and dangerous nature of residential burglaries and the long-standing practice of many states, the court effectively creates a Fourth Amendment right allowing a burglary suspect to flee unimpeded from a police officer who has probable cause to arrest, who has ordered the suspect to halt, and who has no means short of firing his weapon to prevent escape. I do not believe that the Fourth Amendment supports such a right, and I accordingly dissent. The clarity of hindsight cannot provide the standard for judging the reasonableness of the police decisions made in uncertain and often dangerous circumstances. Moreover, I am far more reluctant than is the court to conclude that the Fourth Amendment prescribes a police practice that was accepted at the time of the adoption of the Bill of Rights and has continued to receive the support of many state legislatures.
Whenever an officer restrains the freedom of a person to walk away, he has seized that person. While it is not always clear just when minimal police interference becomes a seizure, there can be no question that apprehension by the use of deadly force is a seizure subject to the reasonableness requirement of the Fourth Amendment. A police officer may arrest a person if he has probable cause to believe that person committed a crime. Petitioners argue that if this requirement is satisfied, the Fourth Amendment has nothing to say about how that seizure is made. This submission ignores the many cases in which this court, by balancing the extent of the intrusion against the need for it, has examined the reasonableness of the manner in which a search or seizure is conducted.
Because burglary is a serious and dangerous felony, the public interest in the prevention and detection of the crime is of compelling importance. Where a police officer has probable cause to arrest a suspected burglar, the use of deadly force as a last resort might well be the only means of apprehending the suspect. With respect to a particular burglary, subsequent investigation simply cannot represent a substitute for immediate apprehension of the criminal suspect at the scene.
Without in any way disparaging the importance of these goals, we are not convinced that the use of deadly force is a sufficiently productive means of accomplishing them to justify the killing of a nonviolent suspects. The use of deadly force to prevent the escape of all felony suspects, whatever the circumstance, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape. Where the suspect poses no immediate threat to the officer and no threat to others, the harm resulting from the failing to apprehend him does not justify the use of deadly force to do so. It is no doubt unfortunate when a suspect who is in sight escapes. But the fact that the police arrive a little late or a little slower afoot does not always justify killing the suspect. A police officer may not seize an unarmed, non-dangerous suspect by shooting him dead. The Tennessee statute is unconstitutional insofar as it authorizes the use of deadly force against such fleeing suspects.
Against the public interest justifying the conduct at issue here must be weighed the individual rights implicated in the use of deadly force by police officers. The majority declares that the suspect's fundamental interest in his own life need not be elaborated upon. This blithe assertion hardly provides an adequate substitute for the majority's failure to acknowledge the distinctive manner in which the suspect's interest in his life is even exposed to risk. Without questioning the importance of a person's interest in his life, I do not think this interest encompasses a right to flee unimpeded from the scene of a burglary.
Majority opinion submitted by Justice Byron White.
Dissenting opinion submitted by Justice Sandra Day O'Connor.
Thank you for joining us for the third part of our program where we're discussing the Supreme Court decision in the Tennessee versus Garner case. To join us for this part of the program, we have a special guest, attorney Ricardo J.A. Pitts-Wiley, someone I know very well. Ricardo Pitts-Wiley, attorney Ricardo Pitts-Wiley, is a partner in the federal practice group and has over 10 years of experience in the area of federal sector employment and labor law. Mr. Pitts-Wiley received his Juris Doctor from American University's Washington School of Law in Washington, D.C. While pursuing his law degree, he participated in the clinical program, and as a student trial lawyer attorney, he represented local residents in the Montgomery County District Court of Maryland. He holds dual Bachelor of Arts degrees in public policy studies as well as African and African American studies from Duke University in Durham, North Carolina. Mr. Pitts-Wiley has practiced numerous times before the U.S. Equal Employment Opportunity Commission, the U.S. Merit Systems Protection Board, the U.S. Office of Special Counsel, as well as before the Federal and District of Columbia courts. Welcome, Ricardo J.A. Pitts-Wiley.
Thank you. That was one of the best introductions I've ever had.
Well,
I appreciate it.
It was a pleasure. And also, we were joking a little bit before that our names are different because you have a J and an A in your name. I don't have any middle names. So I'm thinking maybe I gave you a J and A so to represent judge advocate because we knew what you were going to do in the future as you grew up. One of the things that's important about this program and why it matters we, they, and the people, is we really try to stay abreast of what's going on in the world. And even though we might choose the cases that we're going to discuss weeks, even months in advance, every time we get close to doing a program, we realize that events are happening so fast and so violently sometimes that it can seem that what we're discussing is old news when it's really relevant to what's happening. And in the case of Tennessee versus Garner, police action against men and women of color is in the headlines every day. So I'm going to start the questioning by asking, why was Tennessee versus Garner an important case at the time that it was decided?
Well, the Supreme Court held that a law enforcement officer who was pursuing a fleeing suspect may not use deadly force to prevent escape unless, and I think we're going to get to this exception throughout the course of our conversation, but unless the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. So in a nutshell, Garner was a case that helped to shape law and order in this country. The catchphrase "law and order" is considered by some nowadays to be a dirty term. Particularly in light of all of the negativity that's been saddled on that phrase over the last 5 years or so. But the truth is, most people want or have implicitly agreed to abide by rules and the enforcement of those rules. Democracy, in and of itself it's an idea of governance based on an understanding that we all as individuals sacrifice some freedom for the sake of protection being provided by society. And, protection is provided through a system of rules governing society. Rules need to be reinforced through enforcement. Yeah. And enforcement requires use of force. And so, societies, not just America, but societies in general have grappled with the idea of, how much force is necessary, how much force can be used to be able to try and strengthen and ensure, the structure of our society.
On that same note, there seems to be a level of implicit bias about how law and order is being applied. In the case of Garner versus Tennessee, even though, as I studied the case, it didn't seem to be a major issue, was that the person who was making the decision about the level of force to be used was never questioned about whatever their implicit biases might be, especially in light of the fact that Black and brown people are disproportionately injured in these confrontations with the police. So, why do you think that was the case? That history, in a sense, was factored out of the case?
Well, you have to keep in mind that the Garner case, it was decided in 1985, but the events that gave rise to this case occurred 11 years before that, in 1974. And so, the Garner case, on its face, it seemed to place limitations on the amount of force that police officers could use. But what Garner also helped to solidify, I won't say it started it, or I won't say that it was a seminal case in this regard, but it helped to cement deference being paid to police officers in terms of the execution of their duties. And so implicit bias is oftentimes ignored because you're looking at a set of circumstances not through the lens of the suspect or the victim, but you're looking at it through the lens of the officer who's on duty. And this is not necessarily a reasonable officer standard. You're looking at what that particular officer believed was appropriate under those circumstances. So implicit bias is not something that's been given great weight, and especially not back in 1985.
So with that in mind, what were the limitations that the Supreme Court ruling placed not only on the police, but also placed on potential suspects, or because if we're going strictly with language, you're just a suspect until you're convicted of doing some wrongdoing. So there was the possibility that the person fleeing the burglary wasn't even the right person. So would that have made it okay to use deadly force in that case?
Well, I'll try and you just posed multiple questions. I'll try and break down the questions and answer them hopefully one by one, or at least sufficiently with what I'm about to say. In terms of the limitations for officers, the Garner case, like I said, on its face, it appeared to set limitations on a police officer's use of force. And I think most people would agree that this was a good thing, that this was a positive development. However, Garner also helped to establish that deference be given to the decision making of the officer under the circumstances, which is often why implicit bias is not taken into account at all. And this deference has had an outsized, disproportionate impact on unarmed and unthreatening non-white individuals being killed by law enforcement officials without any kind of redress. So I think that's responsive to your first question. Your second question, I think, is also a very interesting one. What kind of limitations does it place on, and I'll use the word suspect, even though I think that term is loaded in and of itself. But, if you as an individual find yourself in the gaze of a law enforcement officer, what limitations do you have? And I would argue that, there have been a lot of limitations placed particularly on non-white individuals, brown and black people, because to flee, to try and run, to try and save your own life is to risk being shot in the back. But also to stay and to comply also means that you're risking the possibility of being detained and withheld and killed. Much like what happened to George Floyd. He did not run, he did not flee. He complied and he was not resisting. And nonetheless, an unreasonable force was used and he died. Not because of any drugs he took, not because of anything he said or did. He died because too much force was used, even after he had, complied. So yeah, Garner, creates a quandary for underrepresented groups.
So I wonder if we apply the term qualified immunity, which is a police protective system. what difference did the Supreme Court case make in any way? Because qualified immunity basically says the in the moment decision is strictly the province of the police officer if he or she feels that they're doing the right thing, that they're carrying out their duty as a peace officer. So does qualified immunity render Tennessee versus Garner a moot point?
No, qualified immunity or the lack of application of qualified immunity is what allows for officers to be held accountable. Since the Garner case, there have been decisions at the Court of Appeals level, addressing this issue of qualified immunity. And, I do believe that there's a trend, particularly since I'd say 2015 onward, there's a trend toward courts being more skeptical about granting qualified immunity for officers. And I think it's part of this societal reckoning that we're having right now. What's happening in everyday life, it can have an influence on adjudicators and the decisions that they make. And I think that, this idea that officers have full immunity and impunity to do what they want is something that's being chipped at and is being eroded.
So in light of recent events, the last number of years that have given rise to movements like Black Lives Matter and among others, the fact that we are dealing with a racial reckoning in this country, is Tennessee versus Garner, is it still important? Does it still have merit and how it can be applied? I asked that in some way because going back to one of your previous points about you're threatened if you do, you're threatened if you don't. So if that's the case, isn't there a natural adversarial situation that existed before black people and brown people even encountered the police officers? So how does one protect themselves against a pre-existing condition that makes both sides feel endangered?
Well, I do think that Tennessee versus Garner, I think it's still important today, not necessarily its application, but really the purpose that it served of setting a keystone of sorts. The shaping of our society, it's a constant, continual, ongoing process. It must be tended to, it must be molded, it must be shaped repeatedly over and over again. And I think that the Garner case really helped to shape the contours of our law and order. But it still must be honed. So, in terms of the impact or the import of Garner, we have started from somewhere, and we must take those lessons forward for the sake of everyone's protection and safety in society. Sometimes when you set a cornerstone or a keystone, it allows you to focus on other things. And I think since the Garner case, there has been an increasing focus on the amount of discretion that law enforcement officers have, particularly with respect to engaging brown and black people and other underrepresented groups. And I think that this, societal reckoning, that we're having right now, or that we are, that we're witnessing right now, part of that reckoning consists of people from predominant cultures examining themselves, examining the privileges that they either consciously or unconsciously assert or that they have benefited from. And I think that that type of awareness, and not necessarily understanding, but at least awareness that there are, sets of rules at play, there's biases at play that have a disproportionate and negative impact on groups of people, is what leading us, away from officers having, impunity to do what they want. And I think that, where we are right now in society, it makes the Derek Chauvin case all that much more important, because there are a significant, number of people who believe that this case against Derek Chauvin is an open and shut case, or at least it should be, based on the evidence that's been viewed and available to the public. But nonetheless, a significant portion of people also are not convinced that justice will be served, or they're not convinced that the outcome of this case will result in Derek Chauvin being held accountable for murder. And I think that, that lack of confidence is really tapping into, this implicit bias, that needs to be addressed. And it is being addressed. It's an ugly conversation, but it's a conversation that needs to be had. And no one's going to feel comfortable having this conversation, but it's one of those things that has to happen if as a society, we truly value, our own safety, protection, and well-being.
Our final question has to deal with, how does Tennessee versus Garner inform us and instruct us about the nature of our civic engagement, our participation in the electoral process, and the honoring and preservation of a democracy that hasn't always been democratic to us, as people of color, but to not participate seems not to be an option. But so how do we increase our participation, particularly in the electoral process?
Well, it's important that we exercise some personal responsibility. It's important to note that the Supreme Court of the United States, just to use an example, is an entity that is purposefully limited in what it can and should do. As the final arbiter of the law, the Supreme Court is charged with ensuring that the American people, have access to equal justice under the law, and thereby the Supreme Court also functions as a guardian and an interpreter of the Constitution. So even though Garner certainly has its limitations, we can't just lay the blame at the doorstep of the Supreme Court. Garner should really remind us all of our responsibility as individuals to be stewards of the law and order that we want for ourselves and for our communities. So, civic electoral participation, it can help to sustain, those aspects of and help to strive for those aspects of society that most of us believe help to enhance our sense of safety and humanity. And, electoral participation can have a much more immediate effect. I mentioned this before, but, it's interesting to note that it took 11 years for Mr. Garner to get a decision for his slain son. And yet through, electoral participation, change can literally happen overnight. One of the inherent purposes of civic electoral participation includes, being able to promote the quality of community. And the quality of community is inextricably intertwined with the quotient of safety and protection. So, individuals should be collectively concerned about the quality of community, about the quality of society. It has been demonstrated time and again, especially through the historical lens of enslaved and indentured Africans in this country, that, the better treatment for underrepresented groups means better treatment for all. And so, I encourage people to get involved, and if you're already involved, to stay involved, because, civic electoral participation, it matters at all levels. It's not just about being able to influence, who's placed on the bench at the Supreme Court, but it also touches on who are our federal and state judges, who are our law enforcement leaders, who are our prosecutors, who are our legislators, who decides what textbooks will be used to teach our children. All of these things are born out of civic participation in the electoral process. And in the way that democracy is supposed to work is that, the majority is supposed to win. The majority is supposed to rule. But if voices aren't even being used, and you're just sitting on the sidelines, then you really need to examine yourself and what it is you want out of this society. And I encourage people to get involved. I know I talked about, textbooks for kids, and I think that's a very interesting issue about what ends up in history books and so on and what doesn't. But, as a bit of an aside, the category of folks, who need to learn about history in society, it's not just limited to children. Based on my background as an employment lawyer, I know that, in the context of all of this societal reckoning that's been going on, particularly, coalescing around issues of race and gender, the previous administration, issued an executive order, actually took the time to issue an executive order prohibiting the federal government and its contractors from training its staff or providing training about racial and gender bias and stereotypes. So, that executive order has been repealed, but that's a testament to the influence of people actually participating in the electoral process. Had President Biden not been elected, that executive order would still be on the books right now. And there's a segment of the American population who are woefully ignorant, but they are also greatly hungry to learn, and to take away opportunities for constructive conversations, communications between different groups, to prohibit and stymie adults, learning about themselves, learning about their own history, learning about the communities, that have benefited at the expense of others. That's an important conversation for us to have. I'm probably going on a little bit, but
that's okay. But I wonder, because I think about this all the time, that the power structure seems to depend on the ignorance of the people they will power over. That not knowing the rules, not knowing the law, not knowing the history, not knowing things is they depend on that, and particularly for the African American voter being uninformed or unmotivated, so much of the system depends on that, which makes it even more significant what happened with voting rights laws and suppression after the last election, to say, well, we have to make it more difficult for people to participate, but in doing so, we also are depending on them becoming disinterested and unmotivated on their own. All we have to do is put up a barrier, just enough of a barrier to say, I'm not going to wait in line. If I can't get a bottle of water, I'm not going. If I have to drive 20 miles to go to a drop-off location, I'm not going to do it. I wonder about that information that you allude to is a threat to the power structure. A well-informed populace questions power at every level, but an uninformed population just goes along to get along. And I think there are plenty of forces who count on that non-participation and utter ignorance, especially in a time when information is so accessible. I mean, information you can find out things in 10 minutes that it used to take 10 years to do the research on. I have one last question, and that is, Martin Luther King, in his letter from Birmingham City Jail, says that people have no obligation to obey an unjust law. If the Supreme Court, the highest arbiters in the land, make a decision that a portion of people believe is unjust, are they obligated to obey that rule?
Yes, they're obligated to obey that rule at the risk of being subject to enforcement of that rule. But one of the things about American society is that there are mechanisms for being able to challenge in a non-frivolous way laws that are believed to be unconstitutional, laws that are considered to be invalid. And I think that really speaks to the power of civic engagement in the electoral process. Because by voting, by staying informed about what's going on, by sharing and communicating your convictions to others, by running for office, by supporting someone who's running for office, by letting your representatives know that you exist and that you care and that you're watching. These laws are not. They're not developed out of thin air. They're developed by human beings. And so to the extent that you can influence the people who are making decisions about what laws will exist and which ones don't, then you can make change. And so, hopefully you won't have to, live under the yoke of an unjust law for too long. That there is an opportunity, there is a possibility to be able to change it.
So what's happening in Georgia now is Mitch McConnell warned the corporations that are protesting the new voter restrictions, by saying you need to stay out of politics. But really, what he's saying is, to me, that we run this part of the boat, the economic part of it, which is the thing that's most threatening. It's not the electoral process. It's the economics. That nothing changes unless the money is threatened. So how does one balance that with a moral higher calling of justice?
Well, perhaps morality, perhaps morality is an overused and misplaced ideal for society. I think at its basest level, the reason why, or at least one of the reasons why, individuals congregate, come together, and collect amongst each other is to be able to make their life better in some way. And so, along the way, we try to figure out rules for how we're going to engage with each other and so forth. I think businesses have recognized, particularly with the advent of technology, and also, the rise of these younger generations who are outspoken. They are quick to make decisions and to coalesce around an idea. Businesses recognize that, it is imprudent to sit on the sidelines with respect to social issues. That you cannot conduct business in this country without also taking a stance with respect to important societal issues of the day. And I think many businesses have rightfully decided that it makes sense, not only for an economic, bottom line, but also as being a socially responsible, corporate entity, to try and take, I'm going to call it the higher road, even though I rejected the idea of morality. But the idea that underrepresented groups should be treated better, it benefits everyone, and I think businesses are recognizing that.
Well, Ricardo, J.A. Pitts-Wiley, I have enjoyed this conversation. I'm sure it's been informative for our watchers and viewers. We hope that you'll come back and join us at another time for We, They, and the People episode. Our next program is really at the end of this month, deals with the case of Karamatsu versus the United States, dealing with the internment of Japanese Americans during World War II. But just to show you just how we made a decision to do that case 3 months ago. In the 3 months since that time, the issue of Asian presence in America has changed dramatically, and so where it took 11 years to decide Tennessee versus Garner, I don't think most people have 11 years to, not when things are moving so fast. And we're going to have to deal with that because one of the things that we have come to realize in this country, I hope anyway, is you can do nothing in a vacuum. You can make a decision, it's going to affect a lot of things. And there's almost no decision you can make as a group, as a people, as a community that doesn't have a wide-ranging impact on everything. And there's a interconnectedness that cannot be ignored, and we are not only having a racial reckoning, we're having a reckoning of connection too. and I have enjoyed our conversation. And to our viewers, don't forget that Mixed Magic Theater is a 501c3 nonprofit organization. We depend on your donations to keep ourselves going, and even in the age of COVID, we try to stay active and vital. We thank you for joining us. We'll see you in a couple of weeks when we debate the issue of Karamazov versus the United States and the role and the history of America and how it has dealt with its Asian citizens. Until then, thank you very much. Thank you, Ricardo, and to our staff and crew, thank you also. We'll see you next time. Take care now.
Out from the great strip city, a train came. Its cargo was pain and steel, determined to crush the will. Out from the great strip city, pain and steel rode the train. While at yesterday, clouds were rolling away and questions were rolling in.